Good morning, Coldwell Banker George Realty. It's so wonderful to be here with you on this Friday cool morning. So today we're going to go over some of the disclosures for the residential purchase agreement. I won't be going line by line, but I will be highlighting things that I think are important, or things that I've noticed that have been missed. And I see that Doug Meyer is here. Doug, if you have any comments, please jump in. And
I will, thank you.
yeah, please, because if there's something that needs to be said, make sure you're jumping in with me. Okay, so I'm going to get started on the share. Okay. Can you guys, is it up? Okay, so I wanted to start out with this checklist here. So these checklists for the types of transactions are on our website. We had sent out a link to our CBGR website to you through CBGR Marketing sent that brokerage wide. So I think that this is really a nice list, and we have it for commercial, we have it for business opportunities, what leases. So utilize the list, because if you're not real familiar in the beginning, I know that the platforms do put the disclosures in, but I'm a list person. I like to look at it. So whatever helps you in your transaction, I just put stars here because that means that those were populated with the RPA. Okay. So I won't be going over line by line of each disclosure, but like I said, I'm going to highlight what I think that we need to pay attention to. They're all important, but I'll go over what I think is important to highlight. So the wire fraud and electronics funds transfer advisory, super important. When there is a client that will be wiring, please do not, as an agent, send the wiring instructions yourself to the client. We don't send the wiring instructions. That is a function of escrow, or if you're representing a lessor or landlord, have the lessor send the wiring instructions. We don't want to be responsible for sending the wiring instructions. When you have an escrow or anything where a client's going to wire, of course, they're going to sign this form, but also have them, and it'll tell you what they're advised to do. Please have them call escrow officer or the lessor and reconfirm those wiring instructions when they're at the bank. We don't want any missteps. There is wire fraud going on. We've had the title companies talking about it. So the main point on this form is, please do never email wiring instructions to a client. Have the principal do that, or the escrow officer, and advise your client to call that individual and recheck the routing and the bank account number. So we don't want any, thing floating out there to the wrong people, because you'd be surprised they can put one little number difference and you won't notice. It's very difficult. That's why we don't take the responsibility to provide any wiring instructions to any client. Okay,
Michelle?
Yes.
If I can mention, I know somebody personally in Orange County, used to be an agent here, but wasn't very long here. I guess she didn't get properly trained on the wiring instructions. She forwarded the wiring instructions to her client, and she lost her entire commission, $18,000, because that was what the deposit was. She had to give up her entire commission because she did that. So, and if it's more money, you can be liable too. So be real careful on this, guys. Real careful.
Yeah, it's so critical. I mean, they will, they can take initial deposits, through fraud. It's everything. So never touch a wiring instruction is my advice. To me, I'm like hands off. And then I will even tell escrow, do not send me wiring instructions. I don't need them, the client does. And sometimes they have a lock system where they send them through, or the client can go in and pick them up. Please don't touch a wiring instruction. I don't even want to see them.
Yeah, because pretty much you're only doing just the paperwork of that, and then once that happens, the escrow takes over.
Right, escrow or the landlord, the property owner. Yeah, we don't want to touch that. So Fair Housing and Discrimination Advisory is another one with a star. It populates with the agreement. So this is a pretty important disclosure. So if you look at this, and I took time to read it all last night, it is really good. It gives you some examples of positive practices. One of the things you want to make sure is however you treat one applicant on a lease, you treat all, requiring the same documentation, things like that. I have a list of the following documentation that the lessor will request. So you make sure on a lease that you're treating everybody the same. Even when you're selling a property, treat everybody the same. When they come to an open house, even under the new law, and they don't want to sign in, go ahead and let them look. Just hand them your flyer and let them walk around. You can answer a question of how much is it listed for, because that's on your flyer, but don't engage in a lot of conversation because you're not representing them. Okay, so this is a really good form to read in its entirety, but they have the examples here of the positive practices. And when you're leasing, don't tell a client, oh no, I don't think this is suited for you because you can't, the stairs may be hard for you to manage. Let them make that decision. Leave that property open for them to look at. Put applications on the counter. And the safest way is let everybody take an application. So this applies for sales and leasing. Do you have anything to add, Doug?
Well, we had a situation here in Arcadia where the child was severely handicapped. It was a 3-story building, and the agent, out of the pureness of his heart, said, "You know what? This may not be a good fit for you." And guess what? Big lawsuit, and he had to pay. He had to pay out a lot of money.
Yeah,
You guys, when you do leases, only take the application. Don't say nothing. Just take the
exactly.
application and hand it to the landlord. That's it. That's your job.
Yeah, and less is more. Just, be careful on, like our E&O attorney said, and I always play this over in my head, text and talk like you're being recorded. Always do that, because if you do, you're gonna language more careful. I can be very direct and I don't give a lot of information, right? Unless I'm representing somebody and I'm helping them, I'm not going to be engaging in a lot of conversation. Even with another agent, I will be polite and courteous and cooperative, but I'm not going to engage in a lot of conversation. Okay. So, buyers, homeowners, insurance advisory. This is super important. This does populate with the RPA. Make sure that your clients understand right when you're have an accepted offer, or even prior, they should be talking to their choice of their insurance provider and making sure that that particular property can be insured. Make sure they have a commitment before you remove that insurance contingency. Don't remove it with the investigation contingency. If you're not sure they have a commitment, at least leave that contingency open, okay? So very important, make sure that the client gets on it with an accepted offer, because we know that California has had a lot of insurance companies leave the state, okay? So a buyer's investigation advisory also populates with the RPA. So anything with the star will populate. So make sure that they understand that, they can check for square footage, age, the boundaries, wood destroying pests, soil stability. This is a really good disclosure because it gives them some ideas of what they could be checking on. Of course, they'll do a home inspection, and I have a form in here. If they don't do inspections, they're acting against the broker's advice. But I do have a waiver form should they waive that. And I have had over the years one person actually waive it because he was a contractor. He said he did not care to do an inspection. So, but we do need a waiver form. Okay, so these are very important things. So they're going to look at everything. They can drive around at night, check how they feel in the neighborhood, anything like that. That they want to check, that will populate. the CCPA, the Consumer Privacy Act. This populates on everything really. So that's the, you know, it's pertaining to credit. And if somebody has a good explanation, better than I do of it, please jump in. It's what the third party does with the information they collect on a buyer or a tenant. So this is just, that's telling them that the information is collected and may be shared with others. And then they can also, they have some government regulation sites that they can look at that they've outlined down here. So on any deal, including the leases, go ahead and this will populate. Make sure you're getting it signed. Hold on, I got to turn the air down. I'm freezing people out. One moment, please. No, I'm cold too.
Okay.
Can you just push it up, somebody?
72 is too cold.
It's too cold.
I wear a jacket, that's why.
Yeah, yeah, okay.
So you guys just open this?
Yeah, just open it and push the thing up. Sorry, you guys, it's freezing in here because I put it down too low.
To what? It's at 70.
75 is good, yeah. So now we're on the possible representation of more than one buyer or seller, disclosure and consent. So this is a consent disclosure where they are consenting that you may be representing other buyers and seller or multiple sellers and buyers. You may be dual agency on a property. This will populate with your RPA. So make sure that you are providing it. Usually if it's on the RPA, you know, we don't have a problem. Sometimes it's the other disclosures that aren't populating that we need to pay attention. So this is important. If you are representing or you're a listing agent that has a property that resides in a trust, this trust advisory needs to be executed. Let me come down here at the time of the listing. Okay. So at the time of the listing, the real estate broker you're going to sign it and date it, and the seller's going to sign and date here. As a buyer, if you know that property that you are helping the client on is in a trust, and the listing agent did not provide you the trust advisory, please ask them for it. Okay. So the trust advisory will not auto-populate, but if the property resides in a trust, please make sure that you are providing this form. So the SPBB, I'm trying to be logical in how I put the forms in order. We've went over this several times. Make sure that you're checking the box on the RPA to include for your commission, and you put your commission percentage here. And remember that you cannot exceed what you had on your broker compensation agreement with a buyer. If you had 2%, you can't ask the seller for 3%. So make sure that you don't do that. You can't get on this, you can't get 2% from the seller and then turn around and ask the buyer for another 2%. So please don't do those kind of things.
So it's negotiable.
Everything's negotiable, but once you have an agreement with the buyer, you can't turn around and ask the seller to compensate you more. It's only what you asked for in your compensation agreement with a buyer. And the reason you need to be careful because the seller has a right to verify, if they so elect, that you have the compensation agreement at the same percent. So you don't want to be caught up in that where it's different. Yeah.
Yeah, I can see how that can be a little shady. Right?
Yeah, and then it just starts the relationship off not well. So, Doug, you have any comments? Okay.
No, not really. You're doing a great job, Michelle. Thank you.
Okay, brokers compensation advisory. I think we've went over this several times, but make sure that on listings and for buyers that you are providing this form and having it signed, okay? So it explains that everything is negotiable and that the broker may represent a buyer and a seller. And there's optional compensation if you ask for it in your compensation agreement with the buyer, with the seller, excuse me. On the listing agreement, there is a line for unrepresented buyers, and you can put a percent in there or whatever you deem you know, that it's worth to you to represent an unrepresented, or not represent, to work with an unrepresented, because you still have to open the property, let them do their inspections. I presume you're gonna have to stay there because you're not gonna leave a buyer in a property by themselves. So there will be a little bit of extra work. So just make sure if you're taking a listing that you kind of think about that, okay? So make sure that you're getting this signed by the seller and the buyer. Representation capacity, I won't go over in detail, but there is one for the buyer and one for the seller. So if you are representing a seller or buyer that's in a trust, and this is for the seller, but it'll mirror the buyer's form. So if they're an entity or a trust, or they have a power of attorney, which we're in a deal like this now. So I had to bring in a representation capacity, and I had to check the power of attorney box, that they have a power of attorney given to a relative in this case, and the date of that. I also have a copy of the power of attorney. Okay, so if any of this applies and the buyer's not an individual, make sure you're pulling in a representation capacity either for the buyer or the seller, okay? Now, and remember, when you have a listing that is sitting in a trust, they're going to ask for certain portions of the trust through escrow, so prepare your seller for that. If it's an entity like an LLC, a corporation, escrow needs corporate or documentation, LLC documentation. They're checking to make sure it's an active entity. Secondly, that the person that is signing is the authorized signer. Okay, so for me, if I'm dealing with a corporation or an LLC, they're not all formed out of California, but first thing I do is I go on to the Secretary of State for California, and I look up that business to see if I can find the documents on them. And 8 times out of 10, it is a California corporation or LLC. I print those for my file so I know that I'm dealing with the right person. Okay?
The Secretary of State.
California Secretary of State. And you'll do a business search. You type in the name, and then it will populate if there's filing documents, and it's free to print them. So that should give you some information on who the authorized signer is. Okay?
Interesting. That's good. Thank you.
Yeah. So if you're representing FHA or VA, this form is required. Here you're filling out the top. You put in the purchase price here. Now, even if this doesn't appraise up to the purchase price, it says right in here that if the buyer wishes to proceed anyway, then, you know, they can go ahead and proceed even if it doesn't appraise at that particular 650 or whatever it is. Okay. So that's FHA or VA. This is only for FHA transactions that is required, and we have it on our checklist. If you're doing an FHA deal, it's just to get a home inspection. So this is good information, and it's simple form. You just have them sign it that they know that they're advised to get a home inspection.
Advised to get a home.
Yeah. Buyer's inspection waiver. So I have had to do this. If they are going to waive any inspection, the home inspection waiver, please don't just let them waive it verbally, get it on the form. Because it'll say right on this form that you are acting against the advice of the broker. Okay, right here it says the buyer has decided not to obtain a general home inspection. Okay, also for termite, if they do not get the termite report, you know, like let's say the seller isn't going to provide even a report and the buyer doesn't want to do the inspection, normally you can line those up on the same day, the home inspection, the termite company. So if they are not going to have a termite inspection, for your sake, please get this initialed, because it says you're acting against the broker's advice. So, and there's also another that the broker recommends that the buyer obtain an inspection for the following items. So, maybe the broker thinks, you know, roof or whatever, but you can go ahead and fill this out. And then here, if the buyer has decided not to obtain the inspection noted and other, you're acting against the broker's advice. So they have them initial here. Okay, so very important, if they're not going to do the inspections, make sure that you get that waiver for us and for you. Okay, because that means you've had a discussion with them about it and it's good documentation. If the property resides in a homeowner association, make sure that you're providing the advisory so that the buyer can read over it. And as we say in every training on RPAs, if you are a listing agent, make sure you're jumping on getting the homeowner's documents, everything ahead of time, because they do run on their own time frame. Your contingencies don't mean anything to a large homeowners association. And a lot of times it costs money, so you're going to need to talk to the seller to see if they can go ahead and get that. Now, what if the seller says, oh, no problem, I have a set of them. I purchased this property just 2 years ago. What do you say? Well, Mr. and Mrs. Seller, I still recommend that you get the updated homeowners association documents. What if they provided those documents, but those had been updated somewhere or something added or deleted? You do not want to advise anybody to use homeowner documents that they have laying in their drawer. Please advise them to order the new ones. Yeah. And I know it could cost $300 or $400, but it's so worth it. Okay. Residential earthquake risk disclosure. This is required. Now here, you see they have a doesn't apply or don't know. If the seller of the property, because they're going to be the one filling it out, not us, if they don't know, they don't know. It was perfectly okay if they don't know. This is just what you know. Okay. So if they really don't know, they can check don't know on this form. Okay.
And
So
this must be filled by the seller.
by the seller, we don't fill this out for them. Okay. So, and then the seller signs it and the buyer signs it. Water
Michelle,
yes.
this is the camera. I don't know why my video camera is not working, but
Oh.
anyway, I have a comment on the HOA. Now if you have a balcony, make sure that you find out that whether the balconies has been inspected or not, you know, because this is the new law. And I have an instance that the buyer's agent forgot to ask whether there was that the balcony was inspected and you know, and we have trouble later on. So you should ask the HOA whether that balcony, if you have a balcony, in that unit, you should make sure of that. Okay.
There's a disclosure for that, isn't there?
Well, they're gonna give you a balcony inspection report is what I heard, right, Peter?
Right.
The HOA should be providing that.
Right. So you have to ask for it sometimes, you know, they don't automatically give it to you.
Yeah. Okay.
Thank you.
Yeah, I forgot about that. Water.
Yeah.
Thank you, Peter. I totally forgot about that. The water conserving plumbing fixtures and carbon monoxide detector advisory. This is for single family residents, multifamily and commercial built on or before January 1994. So this form, even if it doesn't fall into this time frame, please still provide it, because the carbon monoxide detector, even though there is some reference to it on the TDS, if you could please provide us this form, we have made it required, because there used to be a standalone carbon monoxide detector form that CAR has done away with. So even if this water conserving plumbing fixtures does not apply, this is just a disclosure. Please make sure you give it to us, because it talks about the carbon monoxide detector, which is required. Okay. So it's a one-page form, just a seller and buyer. And all it's saying is that the buyer and seller acknowledge that they have read, understand, and received a copy of this. So it's not saying, hey, you know, I'm going to do something that's not required on the property, but it's just saying, hey, I got this disclosure. So if you could remember to give that to us, we did update the forms. Since the carbon monoxide standalone disclosure is gone, we've made this the requirement. Lead-based paint and paint hazards. This is for pre-1978 housing, sales, leases, or rentals. So this is required within that time frame if the property is pre-1978. So if the seller has any knowledge, they're going to write it in here. We don't write it in. If they have knowledge of lead-based paint, they would write something here. And if they have reports, they would supply them. So the seller or housing provider will sign here. The listing agent will acknowledge and sign here, and put the broker's name here. And it's just saying from the agent that they reviewed the information and certified the best of their knowledge that that information is true and correct. Buyers or tenants acknowledgement, they sign here. Now, for sales transactions only, this can get lost because it's hard to spot. So normally a buyer, I haven't seen a lot that are going to be conducting a lead-based paint test. I really haven't in 20 some odd years. But if the buyer is going to waive the right to have that lead-based paint or the risk assessment, please check the box. It's really easy to miss. And this is for sales transactions only. Check the box. Okay.
Sales transactions only.
Yeah. For sales transactions only, if the buyer isn't going to conduct a risk assessment or inspection regarding lead-based paint, and this is super easy to miss, make sure you're checking the box. You can ask, don't just throw it in, you know, check it and throw it in. Ask the buyer, are you going to do an inspection for lead-based paint? If they're not, you check the box. Okay. Any questions out there before we scroll on? Okay. Water heater and smoke alarm statement of compliance. This is a 2-in-1, so it's going to require signatures on the water heater statement of compliance and smoke alarm. Excuse me. When you are representing a seller on a property, please make sure that these are done prior to the appraiser getting there, because if not, the appraiser can call it out. And if the in the offer, the seller had agreed to do these items, then they're going to be charged with a reinspection fee if that occurs. Okay, so make sure that when you're walking through a property with the seller, when you're taking the listing, look for the smokes, look for the carbon monoxide, ask them if the water heater is strapped. We had one where it was strapped, but the inspector said it wasn't the right strap. So, but the appraiser passed it, but we just put the right strap on later. Okay. So ask the question, look for those. If they're not there, ask the seller to put those in. Okay.
It must be done prior to inspection.
Prior to, well, yes, prior to appraisal and inspection, because that's a good point, because if the home inspector comes in, they're going to call it. So just make sure that you have those in. So the real estate transfer disclosure statement is extremely important. So we're going to fill all this out, County of Los Angeles, let's say. Now, what date goes here? So the date that I use is the date that the seller filling it out, you know, signed it. So the date I use here is the date they signed it, because that's the date that they filled the form out. Okay. So make sure that you have a date here. If not, we'll ask you to go back and date it. Here's very important. You need to check one of these boxes here. if you don't, the form's not complete. So if we notice you didn't check a box, we'll ask you to take it back and ask the seller to check a box. So normally it's no substituted disclosures for this transfer. Or if you have inspection reports that you want to attach to the TDS, you check that. Or additional reports or disclosure, you check that. But generally, you'll see no substituted disclosures for this transfer. Make sure you're checking a box so that this form is complete, that the seller knows to check a box, okay? So important, some people miss this. The seller is or is not occupying the property. Okay, they're gonna fill this out, the seller. We don't do this for them, okay? The subject property has the items checked below. They're gonna go through all of this and check it. Anything that they know of, they're gonna put in here. The best of the seller's knowledge, any of the above are not in operating condition, yes or no. You know, sometimes things don't work, just have them write it on the form. Maybe the garbage disposal doesn't work, things like that. So make sure that they're really looking at this and going through it. Initial for seller and buyer on the first page. And then it's asking here if the seller's aware of any defects or malfunction in any of the following. If yes, you're going to need to provide, you know, the description. Or are you the seller aware of any of the following? Make sure they're reading this carefully and filling it out. It's a very important document. So if you're taking a listing, you know, let the seller have time to fill these out. Don't, you know, like rush them on that day. You can go back a couple of days later and pick the forms up so they have time to formulate their answers and really digest what they're checking on these. Okay, so the seller will sign here. Now you come to the third page. So agent to be completed only if the seller is represented by an agent. So if we're giving them the form, we're probably representing them. So for us, we advise that you just check, see attached agent visual inspection disclosure. So that means you're going to have to do your AVID fairly quick. And because if you check that box and you don't attach the AVID, the TDS isn't complete. So make sure that if you check this box, you do have your AVID attached. And then the agent signs here. So the other agent on the one representing the buyer is going to do the same thing. However, their broker advises them or they want to fill this out is up to them. Okay. And the seller is going to acknowledge that they have a copy of the statement and the agents are going to sign. Okay. So this is really important document. It's not something to look at lightly. Please give the seller time to fill it out. Don't, you know, rush them through it. Okay. So there is, and Peter can probably explain it better, but there are exempt sellers that do not have to do a TDS. So the TDS is required for 1 to 4 residential units. And the transfer of the property that are exempt are new home sales requiring a public report, transfers pursuant to court orders such as probate sales, foreclosure, deed in lieu of foreclosure, and transfers of a fiduciary in the course of the administration of the estate. So if the person is deceased, then I think they would be exempt for filling out the TDS, and I would like Peter to jump in because this is more legal.
Yeah, if the trustee never reside on the property, and if the successor trustee never reside on the property, then they are exempt from the TDS.
Okay.
Okay, and also for the TDS, it has a 5-day rescission period. In other words,
yes.
Yeah, if you didn't sign the TDS, and they have the buyer always have a right to rescind the contract. So make sure that you have the buyer sign as soon as possible.
Yeah. Yeah, and that's thank you, Peter. Also, if you deliver disclosures late as a listing agent, let's say they have a 10-day, they negotiated it down to 10 days for their contingency periods and you don't deliver it till the 8th day, you've just given them 3 more days on
Mhm.
any disclosure because they have 5 days after the receipt of that disclosure to review it. So if you're late, you're adding to the contingency period. So the one thing you never want to do is be late because you don't want to be the cause of adding more days, right? So make sure that you're getting on it quickly for the seller. The SPQ is used by the seller to provide additional information when a TDS is completed, okay? So if the seller is exempt from completing a TDS, the seller should complete the exempt seller disclosure, which we just showed you. It's a 1-pager. It's a lot less disclosure. Okay, so this is simply questions is the seller aware? Are they aware or not? Yes or no? If it's yes, they're going to ask that you provide a document or an explanation for what you're checking yes to. So again, give them time to digest this and don't fill it out for them, please. Let the seller fill it out. Give them time to digest it and look it over and fill it out. I don't recommend that when you're taking a listing, you rush them through a disclosures. I just think, you know, give them some time. People like to have time to think, okay?
Yeah, you're right, Michelle. Don't fill up for the seller, okay? Make sure that you give it to the seller and say, hey, this is a very important disclosure. You have to think about it before you answer yes or no. Because I have one case that that the SPQ, everything was no, and when it comes to the lawsuit, the seller said, well, I never knew about it, and it was all the doing of the listing agent, you know.
Ooh.
That would be a very bad excuse for you.
Yeah. Yeah. And I like email documentation. Once you pick up this disclosure or however you're going to get it back from the seller, regurgitate it back. I would scan it back to them and say, thank you for completing the documentation. I'll be in touch when there's, you know, I'll be in touch with you later for showing or whatever. But make sure that you are scanning back whatever they've given you, because maybe you don't have an extra copy of the completed one when you pick it up. Make sure whatever you get from the seller, you're emailing it back to them. So that, and I always put for your electronic file. So it doesn't look like I'm being weird. I'm just, hey, here's the documentations for your electronic file. Okay?
Michelle, question. Can we go back to number 7D?
Which form is it?
Same format.
7D?
7D. Yeah.
Okay, so we have a question in the room on 7D. 7D.
Okay.
Okay.
Check it yes here.
Yes.
Okay. Then we need to go to F, explanation here to say why we painted.
No, if you check yes here.
Means we paint in.
Okay, so I would reference it 7, what is it, D?
E.
So E,
E.
D. Okay, I would put 7D. Seller painted the property on if interior or exterior, whatever the case may be, within the last 12 months. Maybe they did paint touch up, maybe they did a full, but you need to say something if it's interior, exterior.
Okay. So you do need to explain
Right.
right here.
Yeah, because any part of the property that could mean a detached garage, that could mean the exterior, the interior. What did they paint? Where? Was it interior, exterior, detached garage, inside the garage? You know, because maybe they only painted a portion.
So this is just write it down portion of.
So anything you, let's say if you check yes, in any of those boxes, there's your explanation right there in that bottom one, right? That bottom line below the F, that's what you explained.
Yeah, and please always reference the number because I've seen it where they've
You're like,
written
wait.
all these things and it's like, wait, what? What does this belong to? So I always want to be careful and reference the numbers. Peter, do you have anything to add to that?
That's what, I'm sorry.
The painting, I always put, like, if they painted interior or exterior, that's it. Within the last 12 months, I don't go into more explanation.
No, you don't need to go more into
Yeah.
the explanation, yeah.
Okay.
No,
So,
I have comments on the SPQ where they ask about the unpermitted
oh,
remodeling.
yes.
Now we have a big case where there was a lot of unpermitted remodeling. So the first thing you ask the seller is that, have you done any remodeling? Okay, and if they said yes, and they said, well, was that properly permitted by the city? You know, make sure that you ask that question because you know, that's a big thing. If the city comes in and have to ask the buyer to tear everything down to restore it to the original condition before they issue any permit to do any remodeling. So it's a big expense. I have a case right now that involves like $400,000.
Wow.
Yeah, so a lot of money. And I don't know how the agent is going to explain what she did for putting no and on all those important questions.
Yeah. Yeah.
Make it as a, bonus room,
Yeah.
you know.
Yeah, and you just, Jimmy just mentioned amendment. If during the course of, your disclosure period or you're in escrow, anytime you find something out, you can amend the TDS. And we recommend that. Let's say you find something out not you, but the seller finds something out they wish to disclose. Make sure you're amending it, even if you're giving them the 5 extra days because it's close to removal time. Yeah, you must do that. Don't just not amend the form if the seller says, hey, I just thought of this. Make sure that you're doing, adding that to the TDS and sending it to the other party. Okay?
Yeah, that's a good advice, Michelle.
Yeah. Yeah, thanks for bringing that up, Jimmy. So we've had I can't remember the gentleman's name, but he's the guru of the AVIDs. Come in here. Anytime we have him scheduled, please make sure you come in. I've learned a lot from him. So the California law is not requiring the agent to inspect areas that are not reasonably and normally accessible, areas offsite of the property, public records and permits, common areas of planned developments. Okay. So the AVID is important that you do it in a certain manner where you're not making conclusive statements, meaning if you see, let's say I see a black mark on a wall, you can just note mark on wall at north corner, primary bedroom. You don't call out what you think that is because we're not testing for mold. That's not our job, but you can point out that you see something. Okay, so when you are documenting on an AVID, it's just things that have material effect on the property of desirability or the cost. It's not, oh, there's a chip on the border, the floorboard. No, that's not a material cost or, it's not going to affect much. It's things that are material to the property that may affect the desirability or the cost of the property. So, and don't do an inventory list as the gentleman told us. Like, don't go, oh, the living room has, this 2 ceiling fans and this and that, because he said, if you start doing an inventory list in one room, you're going to have to do it through all. So you are noting material items that would be important for a buyer to know on this form. Like, let's say you notice, I think it's material if you see a big crack across the kitchen tile. You know, that could cost some money. Or you notice that the countertop has a big crack going across it, things like that, but not chips in paint or, you know, a spider web.
Cracks on the ceiling.
Yeah, you can say, but don't, if you see cracks on a ceiling, which is a good one, just say cracks noted on ceiling. Don't describe them. Don't say short, long, not serious, serious, just cracks. You know, we don't put our own spin on it. So I guess that's the way to think of it. The way that we were trained is don't spin it, just what you see. And don't make any conclusive statements that, you know, that's not our job. It's just to point it out. The other is important on this. And if everybody needs training on AVID, we can probably get the gentleman back in. He's really expert on training on this. But other is very important. Let's say the property, which I've sold one, was sitting right across from a freeway, but of course they have the big retaining wall. Well, there's probably still going to be some noise, right? So you could put subject property is across from a freeway, or subject property resides on a golf course, or subject property is near a school. Why would that be important? Because there's going to be more traffic, things like that. So anything like that, or subject property is near a train track. Anything like that that's factual, that property is near, that you can think of, or near an airport, which the NHD report will disclose. But anything that you notice that subject property is near, because that gentleman a few years ago said that they had seen a lawsuit where, even though it was abundantly clear that the freeway was near the property, they said, oh, it's noisy and you didn't tell us. So if you see things like that, just disclose it in the other. And very simple, house is across from a freeway, house is a few blocks from a school or near a school. Don't count blocks, just near a school. Okay. You have anything to add, Peter?
No, you're fine.
Okay.
Yes. Yeah.
So they added this box here. The real estate firm that performed the inspection is here. So that's easy. And then the buyer will sign it. And they made it, the real estate broker who did not fill out this AVID, the other broker signs here. Okay. So make sure that this form is done to attach to your TDS, because we recommend you just simply check, you know, see AVID. And okay. So a statewide buyer and seller is a very long disclosure. I won't go through it, but it is a lot of advice on, and you can see they even have the table of contents going over formaldehyde, environmental hazards, geologic hazards. So this is just a good overall form that you do. It is required on transactions. Some people attach it to the offer, and I don't recommend that because it makes your offer 15, 16 pages longer, and it's a lot. And anything, just remember, any disclosure you attach to the offer that you check a box and put that it's attached goes to the lender as well. So be mindful of that when you're filling out your offer. Okay. So this is 15 or 16 pages. And you just have, they used to have us sign every page, but thank God that's gone. Initial. And right here, they sign back here, the buyer and the seller. Okay. Verification of property condition is defaults to 5 days and prior to close. In the RPA, we went over this a lot. Make sure that if the seller had agreed to do any repairs or anything, you're kind of checking for that. You don't have to climb a roof or anything. And also be asking for those invoices and receipts if the seller did agree to do some repair, you know, so that you do your due diligence for your party to make sure that, you know, everything was done as agreed in contract or on a request for repair.
Just to show proof, right? So they.
Yeah, just to show proof that it was done and that you asked, okay? So the VP can be waived if the buyer says, I don't want to come, I'm not going to come, or I'm out of state, I'm not doing it. Make sure you check box number 3 that they're waiving it. Okay. It's really important on this, because there could be debris left on the property. I like to go a little before 5 days, maybe 8 days before close, because I've seen debris left on the property that we have to eventually pay for to have hauled away. I've seen a lot of paint left on a property, which is not easy to haul away. And if they've included the refrigerator, washer, dryer, you want to make sure you're over there, making sure those things are still there, okay? In case there wasn't a mistake by a mover, because I did see a mover make a mistake and then have to bring a refrigerator back. You know, so very important to waive it if they're not, but even if your buyer waives it, I would still kind of go over there and, you know, not certified to the buyer that I've done their walkthrough, but I would kind of look, and if I don't see the things done that was agreed to contractually, I'll be asking the listing agent, okay? Square footage and lot size disclosure, we don't require it, but it's not a bad form. Because sometimes the seller will say, oh, the property's really 2,000 square feet, but the assessor's data may say it's 1,800. So this form is good for that. If you want to document that. So again, we don't require it, but it's not a bad form, especially if you know that there's some discrepancy in square footages.
And Michelle, it's good to mention it to the buyer that the price is not, you know, indication how many square feet of
Yeah.
of the property. It's just approximate footage, and it can differ from the one agency to another. You know, like assessor's office and the cities. And if they want to verify the exact footage, they have to do it on their own.
Yeah, we don't go, yeah, that's a good point, Peter. Don't go to the city and start trying to verify that square
Yeah.
footage for somebody, because
Let them do it. Yeah, let them do it.
yeah, you could get in trouble doing that. So make sure that you're not going to the city for them. They need to go themselves. If they need a ride and you want to take them, sit back and just sit in your car, let them go to the counter. Don't go to the counter for them. Market conditions advisory, I kind of like this, this disclosure. So this is just saying that, you know, as a buyer, you're responsible for determining the price you want to offer. It's not up to us to tell them. Of course, we can direct them, we can provide some comparables, but ultimately it is their, you know, their deal. So this is a nice disclosure. We just have them sign it, okay, and date, buyer and seller. So I pulled in this because sometimes we're selling property. It could even be a single family house where the owner has used it as an investment vehicle. It's a rental. So if you know that, make sure that you provide them an exchange advisory, and they can talk to their own tax accountant, lawyer, or CPA, and find out their own tax consequences. That's not for us to do, but this is just advising that there could be certain tax penalties. You know, if they're not, you know, exchanging it, or maybe they do want to exchange it, it's a good time to discuss with them. Hey, this has been a rental. Are you going to do a 1031 exchange, or are you just selling outright? Do you have anything to add to that, Peter?
No, you're good.
Okay. So, and the seller would sign this and the agent would sign it. This is just that we know we've talked to them about that if we know it's been income property for them. Okay. So any questions? We're right at the hour. I want to see. Okay, so next time we're going to finish out the disclosures. And again, we'll be going over what we think the top points of them are. They're all important. I suggest that, you know, you read them, especially the fair housing. It has a lot of good information in that disclosure. And any further comments from Doug or Peter?
Excellent job, Michelle. Thank you very
Yeah,
much.
Oh,
Yeah.
thank you.
Good job,
Okay.
good job. Okay.
What was the website of the CBGR?
I'll send it to you. I have it on my phone. Okay, thank you all very much, Coldwell Banker.
Thank you.
Bye-bye.
Bye-bye, everybody. See you next time.
Thank you. Bye-bye.
Thank you all.
Thank you.